Incomplete or legally ineffective transactions, well, the courts have struck down these transactions basically because they're legally invalid and they never occurred. And I'm going to give you an example, and the example is taken from the facts in the Antley case, which is referred to at the bottom of the slide. A wishes to sell property to B. Again, if A sells the property to B, he's going to pay tax. So A purports to form a trust, and then he transfers the property to the trust, which is for the benefit of his wife, and therefore tax advantaged. The trust then purports to sell the property to B. Neither the transfer to the trust nor the sale of the trust would be subject to Canadian tax if the transactions had been completed effectively, nor would the transaction necessarily have been subject to our GAR. However, due to advocate error, whatever, the trust doesn't happen to get formed by the date that the property is due to be transferred to it, and it's still not formed by the date on which the transfer from the trust has occurred. So what you have is an ineffective or incomplete transaction under Canadian law, and in fact, the decision right now is under appeal to our Federal Court of Appeal. The tax court found that it was an ineffective transaction. I'm not going to talk very much about substance and over form. It was not something which the Canadian courts actually were interested in adopting. When they did talk about substance, they talked about legal substance. And so we'll move from that to the step transaction doctrine. And the step transaction doctrine is another of the doctrines which didn't find much favor in the Canadian courts, but in fact, as we'll see in going through the slides, the step transaction doctrine did become an important part of the Canadian GAR. And for you, rather than spell G-A-A-R each time, the general anti-avoidance rule in Canada is referred to as the GAR. Lastly, the business purpose test. Only transactions with real business purpose or any legitimate non-tax transactions can withstand a challenge. Again, the Canadian courts were reluctant to apply this test, and in fact, the Supreme Court of Canada expressly rejected it as an independent anti-avoidance judicial doctrine. However, when we look at the GAR, we will see that there are sounds that are similar to the business purpose test, which have made their way into GAR. One other comment, Gregory and Halvering is regarded as the case in which originated the idea of the business purpose test. John is going to talk to you in a great deal more detail about that case, but I was very interested when I was reading it to notice in the context of Canadian law that it actually included comments as to abuse of law and abusive activity in the context of the legislation in the judgment. Okay, so we'll move on now to immediately pre-GAR. Every country has a landmark case, and pre-GAR, the landmark case in the anti-avoidance area in Canada was a case called Stubart Investments Limited. It was a 1984 case deciding effectively on facts that occurred in 1966. You can tell our courts are very timely in their consideration of issues. In any event, in Stubart, A Co owned B Co and C Co. And B Co had losses and C Co had profits, and Canada does not have a consolidation regime. So A decided to sell and cause C to sell the assets of its business to B. nothing really changed. C was nominated as agent for B to carry on the business, and everything went on as before, except that C paid the profits over to B at the end of each taxation year. B reported the income, offset it with losses, and utilized the losses. The tax department was very upset by this, challenged the transaction on a number of bases, and the Supreme Court of Canada, leaving no doubt in anybody's mind, found that there was no sham, that the transaction was not legally ineffective, rejected the business purpose as an independent doctrine, and adopted an object and spirit test, which you can find in the quote here in the slide, and that will become important later when we talk about our GAR. The Canadian government was basically left out in the cold. And to add to the difficulties, there was a lot of public dissatisfaction with the Canadian Tax Administration. As a result of the Stubart decision, aggressive tax avoidance transactions became more prevalent, and there was a huge shortfall in corporate tax revenues. The government tried to address each situation as it arose, and eventually announced that it was going to introduce a new general anti-avoidance rule. The rule took 2 years to vet and to discuss with, and to gain consensus, if you will. And in the original legislation that was proposed, the government proposed a business purpose test. And it also qualified the tax benefits to requiring results to be significant. Both elements were rejected by the legislators, and as a result, the government replaced the business purpose test with a primarily for bona fide purposes other than to obtain a tax benefit test, removed the significancy in the tax benefit, and added a carve-out for transactions that were not considered to be abusive. And the reason for that carve-out in the Canadian legislation was the concern of the legislators that the Act itself contained specific provisions designed to induce taxpayer behavior, and that these inducements should not be overridden on the basis that there was a tax benefit which had been generated, or that a transaction had been entered into primarily for a tax purpose. I'm having trouble here. Oh, there. We're going to skip over the legislation, which you can take a look at when you get the slides, and move into the actual examination of the rule. First of all, it's important to understand that the GAR is a provision of last resort. Over the years, the Canadian tax regime has become increasingly complex, and the Canadian taxing legislation itself is replete with numerous examples, endless examples of specific statutory anti-avoidance rules to deal with very specific fact patterns. So the GAR is intended to follow up and to cover up situations in which those specific anti-avoidance rules or other concepts would not be available to the government.